Part of the problem with understanding resulting trusts is that people are often not aware of where the term comes from or how it is used. Well, within the context of English law, the resulting in resulting trusts comes from the Latin resaltare, which means literally to jump back. And so we're dealing with the idea in this lecture of property that is maybe transferred to another person, but then jumps back to the original person who actually gave the property in the first place. And I think once we have that basic understanding out of the way, we can begin to look at different examples and also categorizations of resulting trust, where this jumping back idea comes into full force. So with that in mind, let's get started. We can start off with a couple of examples of resulting trusts from Lord Browne-Wilkinson in the case of Westdeutsche Landesbank and Islington London Borough Council from 1996. In the first instance, we have a settlor who is trying to create a trust, but the problem is that there are unknown beneficiaries of the equitable interest. And the problem with this is that English law hates the idea of property existing without an owner. And so how does the law of resulting trusts help to solve this? Well, the property essentially just results back to the settlor, and that is the way that that situation is solved. In the second example, it's again very simple. We have a piece of property or land and various people who are contributing towards the purchase price. And if you contribute 15% of the purchase price, then you are entitled to 15% of the equitable interest under a resulting trust. Very simple. And originally the idea behind this was that it was based on the intention of the trustees, but we saw in the first example that really we're looking at the intention of the settlor as the important thing here. And so a better solution was come up with by Vice-Chancellor Megarry in the case of Vandervell No. 2 from 1974. And he distinguished between automatic resulting trusts and presumed resulting trusts. And we'll explore each of those in turn now. So automatic resulting trusts is based on the idea that all owners of equitable interests have to be identifiable, as we talked about in the first example. And where that fails, then we have a resulting trust that goes back to the settlor, or jumps back if you like. But why might these trusts fail? Well, as well as the idea of certainty of objects that we've talked about in previous lectures, we also have things like condition precedent, which is a condition that has to be met before the trust comes into being. So, for example, the beneficiaries have to get married and then they don't do so, and therefore the trust fails. Or a condition subsequent, which means that the trust is in existence, but will fail if a certain condition is then subsequently met. So the example, again, beneficiaries have to remain married, but if they got a divorce, then the trust might fail, for example. Another question around automatic resulting trusts is what happens to surplus property that comes out of the original trust. And in a general sense, the extra property that is created or exists would simply result back to the original settlor. Again, a bit like the first example. And the authority for that is Trusts of the Abbott Fund 1900, although there are a few exceptions. Firstly, for charitable trusts, the property is applied under the si pre doctrine, which basically means that it's applied to the charitable purpose as closely as possible. Secondly, it's possible for the beneficiaries to essentially wind up the trust themselves under the principle of Saunders and Vautier that we've also talked about in previous lectures. And finally, for unincorporated associations, the property is very simply distributed amongst the members anyway, and that comes from the case of Rebutting from 1978. Before we move from automatic resulting trusts onto presumed resulting trusts, we also have to look at a sort of very specific example that's nevertheless important, which are called Quistclose trusts. And these are basically another variation on resulting trusts that comes from this specific case in 1970. And so we start off with a razor blade company who has to pay dividends to its shareholders. But the razor blade company is not doing very well financially, and so they have to get a loan from Quistclose Investments Limited. Now, the problem is that the problems get worse for the razor blade company, and so what happens is the bank comes in and they try to grab that money that is intended for the shareholders. But the courts in this case said that there was a resulting trust created because the intention of the loan money was to pay the shareholders. And so the bank can't just come in and undermine the purpose of that trust simply because they want to get paid as creditors. And so the court dismissed the bank's claim and that resulting trust was created. So for Quistclose Trust, the only thing you need to remember is that where there is loan money with an intention, with a specific intention, then a resulting trust will be created. That's enough of that though. Let's move on to presumed resulting trusts. And these are examples of resulting trusts where instead of the trust failing, we instead have a presumption that the property will pass as a gift from one person to another. And the case law bases this on certain specific relationships. In particular, we have father and child, which comes from Bennett and Bennett. Although interestingly, the law is rather sexist in the sense that it doesn't allow a mother and child relationship to have that presumption either. And we also have the example of a husband and wife in Tinker and Tinker from 1970. And this is possibly a bit more common nowadays, especially with things like a joint bank account between a husband and wife, which will be a presumed resulting trust. And it's almost based on the idea of a joint tenancy. And so you have principles of survivorship. So if a husband and wife had a joint bank account and then the husband died, well, the joint bank account would then go into the property of the wife. It would result back to her. This is also a quite important principle of voluntary gifts as well, in particular personal property. In Re Vino Gradoff from 1935, we have the instance of shares. And so we had a grandmother who owned some shares, and she created her granddaughter to be a joint shareholder. And when the grandmother eventually died, this principle of sort of survivorship meant that the shares were part of a resulting trust, a presumed resulting trust based on it being a voluntary gift. And so the granddaughter was entitled to keep the shares because she was a joint shareholder under this presumed resulting trust. In terms of land, this is also possibly open to the idea of a presumed resulting trust as well. The case of Hodgson and Marks is a pretty good example. But generally for property, because of the requirement to have things written down and contracts to be signed and things like that, generally speaking, it's constructive trusts that apply there, but just be aware of it. Finally, with presumed resulting trust, we can go back to the second example we talked about right at the start about the contribution to the purchase price. In Lloyds Bank and Rossett, this was expanded to also include contributions to the mortgage, and this creates a resulting trust over the property based on the level of contribution. The contribution, though, does have to be directed at the acquisition, and so again, the law being rather sexist in Burns and Burns, things like childcare or contributing to the shopping or the raising of a family doesn't actually count enough to guarantee you an equitable interest in that property, which is probably a little bit harsh, but it does help to establish certainty in the law. So the reason that these are presumed resulting trusts means that there is a presumption that the court makes, but as with any legal case, that presumption can be rebutted. So we talked a little bit earlier about joint bank accounts between a husband and wife, but it's probably not difficult to imagine the type of situation where the husband goes a bit mad and buys a Ferrari, or the couple are about to get a divorce, and so one of the husband or the wife decides to empty out the bank account before doing so. And so based on that, there has to be an ability for the other party to essentially rebut the presumption and say that, yes, originally this bank account was intended to be shared, but the husband has gone completely off the rails, and therefore it's not fair that he should basically be allowed to spend all of this hard-earned money that I've also worked for just to spite me. And so the courts will look at the factual circumstances around the case, as in Young and Seeley, and there might also be variations based on the agreement between the husband and wife, for example. If the property is transferred to a family member to avoid tax, and then the family member decides not to actually give the property back, then it is possible that a resulting trust will be created in favour of the original owner, and the family member would have to return that property. And that comes from Secon and Alyssa from 1989. In a similar type of situation, we're also possibly looking at cases of illegality where property is transferred from one person who is in a lot of financial trouble, whether that's business related or loan related, and in order to avoid losing their property, they try and avoid the creditors by passing that on to someone else. However, this is clearly illegal, and therefore the court has to sort of have a difficult think about what they do in this type of situation. And originally, the courts wouldn't allow resulting trusts in any cases of illegality. And this got its authority from Gascoigne and Gascoigne in 1918. The law did change a little bit in the early 90s case of Tinsley and Milligan, where Tinsley owned a house and Milligan contributed towards the purchase price. But the reason that Milligan was not listed as an owner was because the couple could get more money if from benefits if it was just listed as Tinsley's house. So when the couple split up and Tinsley tried to get all of the money for herself, Milligan was in a problematic situation because on the one hand she contributed to the purchase price and therefore there should be a resulting trust. But on the other hand, she'd also been a party to this illegality, whereby they were trying to claim more benefits and more money from the government than they were actually entitled to. And so the question was, what should the law do in this type of situation? And the courts decided that there should actually be a resulting trust created, but it didn't really resolve the issue around illegality. And essentially they were allowed to benefit from their illegal actions. Fortunately, the law has developed again since then, and this was very recently in the case of Patel and Mirza from 2016. And Patel gave Mirza about £600,000 to essentially invest illegally in certain investments where Mirza had inside information. Turned out that the information was wrong, and the question then was, could Patel get his £600,000 back, even though it was illegal to actually invest that money in that way on the basis of insider information in the first place? And the courts did this time address the question of illegality. And they said, well, really, it's for the criminal courts to deal with the issues of illegality. And all that the civil court should be looking at is, would the public interest be harmed if the illegal agreement was enforced? And so Patel actually won that case and got his money back, and the contract was enforced. There was a resulting trust for the £600,000, which was good for him. But then it leaves the criminal case open, and it's for other parties, for other courts to bring prosecution against those people for the insider trading. Similarly, in Tribe and Tribe, resulting trust was allowed because the illegal purpose had not been carried out. Again, I think probably nowadays on the back of Patel and Mirza, you would maybe look more towards the public interest test when you're applying the law in this area, but that's still an important thing. And another important factor related to illegality is section 423 of the Insolvency Act 1986, which gives the court wide-ranging powers in reallocating property. So if the courts suspect that someone has transferred property in order to avoid creditors, then the courts do have that power under section 423 to make orders in order to ensure that they're not avoiding their creditors. And that's a really wide-ranging power. It's actually probably a little bit too wide-ranging, but that's a topic for another lecture. And the very final thing that we're going to talk about, I promise, is the idea of mistake. And obviously there's no resulting trust if there was an intention to transfer the property in the first place. So if there's no mistake and there's an intention to transfer the property, then that should be absolutely fine as per Westdeutsche Landesbank, the case that we mentioned right at the start. But there is an exception if the person who received the property knows that receiving it was actually a mistake, and that the transferor or the original settlor didn't intend to transfer that property at all, and in those types of situations a resulting trust will be created and the property will revert back to the original person who owned it. And there we have resulting trusts. If this topic comes up as a part of a problem question, then the first thing that you want to do is to distinguish between whether it's an automatic resulting trust or a presumed resulting trust. Once you've got that distinction sorted, you can then apply the law on that basis. If this topic comes up as an essay question, then there is a number of different issues and factors that you might want to consider. Is the categorisation useful? Is the law quite sexist when it comes to presumed resulting trusts? And when it comes to illegality, how does the decision in Patel and Mirza from 2016 equate with the idea that those who come to equity should come with clean hands? There's a lot to think about there, but in the meantime, leave a like if you enjoyed this video. Make sure to subscribe for more videos in the future. And if you've got any questions or comments, leave those below and I'll try and get back to you. Thanks very much for watching. Bye!